decision over whether or not family members, those giving victim impact statements later this morning, should be allowed to stay in the gallery. Still with me, Joseph Tully and Walter Gabriel. Walter, I wanted to get your take on the defense argument here as to why they should be excluded under the rule of sequestration. And of course, the judge's argument really was that these are scripted statements. They can't deviate from these statements. So would the rule even apply?
Excellent discussion for starters on sequestration. You hardly see this fought over because it's generally understood. Witnesses only observe, they only testify to what they observe, and that testimony would help prove or disprove whether the defendant committed the crime. But here, as we stated earlier, this is a very emotional part of the trial. And the witness sequestration, he's hoping to prevent witnesses from crying and making other nonverbal gestures in front of the jury, which would impact their emotions in deciding whether this defendant, deserves to die or live for the rest of his life incarcerated. So he's being a zealous advocate. I like the argument he made. Is he right? We'll see on appeal. But I think the judge was right because the witness's testimony is all pre-written in their handwritten notes. So their testimony will not be influenced. So under the letter of the law with sequestration, it's not being violated. But the defense attorney is clearly trying to prevent the nonverbal cues that the witnesses are going to present to the jury because they will be very emotional sitting through other witness impact statements.
Exactly. Let's listen in. It sounds like the judge is talking.
Does anybody have anything to